Seminado. Seminado register. Conference. Conference. Conference.
Am I audible?
Yes,
Yes.
Ananya. Sure. Good morning, sir. Good morning, sir.
Good morning.
A very warm and pleasant good morning to each and everyone present here. I am Ananya Ashu, a second year student of CNLU Patna. I welcome you all to the national seminar on examining contemporary constitutional challenges, rights, privacy, and federalism in India on behalf of the Society for Constitutional Law Discussion. and it is my pleasure to serve as your host for today's inaugural ceremony. We are gathered here at the auspicious occasion, a place of deep academic significance, to delve into some of the most pressing issues facing our constitutional framework today. This seminar is organized by the Society for Constitutional Law Discussion, an esteemed platform committed to fostering dialogue and scholarship in constitutional law. Talking about the Society for Constitutional Law Discussion, it is a premier organization dedicated to fostering scholarly discourse and research in the field of constitutional law. Founded with the mission to bridge the gap between constitutional law theory and practice, this society serves as a vibrant community of academics, practitioners, and students alike. It was established in the year 2020 by the students of Chanakya National Law University. The society operates through various activities, including hosting seminars, workshops, and conferences on pressing constitutional issues, as well as publishing a scholarly journal that features cutting-edge research and insights from leading legal minds. Additionally, the society engaged in educational outreach, providing resource and learning opportunities, enhance understanding and appreciation of constitutional law among wider audience. This seminar is a pivotal event organized by the Society for Constitutional Law Discussion. This seminar aims to foster a deeper understanding and discussions on key issues that impact the framework and interpretation of constitutional law in India. Coming to the objectives of this seminar. This, the objectives of this seminar is designed to address three critical areas. First, privacy. In the digital age, the right to privacy is continually evolving. This seminar will explore the current state of privacy laws in India, challenges in balancing state interests with individual rights, and the implications of technological advancements. Second, rights. Human rights and their protection under the Indian Constitution will be scrutinized, especially in light of recent legislative judicial developments. Discussions will focus on how these rights are interpreted, implemented, and challenged in contemporary scenarios. Thirdly, federalism. This seminar will examine the distribution of powers between the central and state governments, a key aspect of federalism in India. This includes debates on state autonomy, central oversight, and tensions that rise from overlapping jurisdiction. Benefits of this seminar is that it will bring together a diverse group of participants, including academicians and scholars, experts from various law schools and universities across India will present research papers and engage in debates. Next, it will benefit legal practitioners and judges. Those who apply constitutional law in practical settings will provide insights into the real world implications of theoretical discussions. Also, it will benefit the students and young researchers. The next generation of legal professions will gain invaluable exposure to advanced discussions and networking opportunities with seasoned law experts. Now, coming to the format of today's seminar, it includes 8 technical sessions covering privacy and data protection, free speech and expression, federalism and governance, same-sex marriage and LGBTQ plus rights, electoral system and democracy, constitutional law and technology, federalism and legislative relations, and at last, rights and social issues, each featuring expert panelists and keynote speakers to explore pressing issues within these thematic areas. The expected outcome of the seminar includes publication of papers. The selected papers will be published in the TSCLG journal, contributing to scholarly literature on constitutional law, policy recommendations. Discussions may lead to recommendations for policy adjustment or new approaches to interpreting the Constitution. And at last, enhance network. Participants will build connections that foster future collaboration in academia and legal practice. At last, this seminar not only aims to enhance understanding and stimulate scholarly discussions, but also seeks to influence the practical application of constitutional law in India, making it a significant event for all stakeholders in the field of governance. Now, I welcome Mr. Piyush Raj for his welcome address. Mr. Piyush Raj, sir, is a senior editor at the Society for Constitutional Law Discussion. Sir, please.
Sir, you're muted.
Yeah, thank you, Anya, for your address. Good morning, everybody, our esteemed guests, speakers, colleagues, and the presenters present here. I'm Piyush Raj. I'm senior editor at TSCLD. It's my immense pleasure to welcome you all to the national seminar on examining contemporary constitutional challenges, privacy, rights, and federalism in India, organized by our own Society for Constitutional Law Discussion. Today, we are gathered here not just in the spirit of inquiry, but to foster a deeper understanding of our Constitution's dynamic and evolving nature. As we delve into crucial issues like privacy, rights, and federalism, our aim is not only to discuss these challenges, but to forge pathways towards effective solutions. I'm thrilled to see such a diverse group of participants, including but not limited to eminent scholars and passionate students who are ready to engage with complex constitutional questions through 52 insightful paper presentations. Your contributions are vital as they bring fresh perspective and innovative ideas to the fore. I would like to take an opportunity to welcome our chief guest, Professor Dr. Ajay Kumar, Professor of Law and Dean Academic Affairs at Chanakya National Law University, Patna. I'd also like to welcome the guest of honor for the seminar, Professor Dr. Salendra Gupta, Professor of Law at Banaras Hindu University, and also the Editor-in-Chief for TSCLD Journal. I'm very glad to have you all to the panel today. I'm pleased to thank each and every keynote speakers for the technical sessions, who are distinguished figures in the field of constitutional law. Your expertise and guidance are invaluable to us, and we look forward to your enlightening address. Let us take this opportunity to learn from each other, challenge our preconceptions, and contribute meaningfully to the ongoing discourse in constitutional law. I'm confident that the discussions we initiate today will resonate beyond the walls of this seminar. I once again thank you all for your enthusiastic participation and for contributing to the success of this event. Let us proceed with an open mind and a commitment to making a significant impact. Welcome once again to you all, and I wish you a very fruitful and engaging seminar for the next 4 and 5 hours. Thank you so much. Thank you so much, sir, for here, and thank you so much for being in the panel.
Thank you, sir, for your words. Now I welcome Professor Dr. Shailen Gupta, sir. Dr. Shailen Gupta, sir, uh, for his guest of honor address. Dr. Shailen Gupta, sir, is a professor of law at Faculty of Law, Banaras Hindu University, Varanasi, India. He has special interest in constitutional law, jurisprudence, environmental law, judicial process, free legal aid, and service law, clinical legal education, law and policy, public policy, etc. He is Dean and Coordinator at Faculty of Law, Banaras Hindu University, Varanasi. Over to you, sir.
Thank you very much. Am I audible?
Yes, sir.
Okay.
Yes, sir. Yes, sir.
So very good morning to all my learned colleagues and particularly Professor Dr. Ajay Kumar sir, a senior professor at Chanakya National Law University and Honorable Dean Academic Affairs, and he has served in many capacities in the university. He is a well-known professor who is the chief guest of today's inaugural session. My young friends, Mr. Ayush Kumar, who is taking a lead role in running this Society for Constitutional Law Discussion, and Ms. Ananya Ashwi, who is comparing this session, and then Piyush Raj, senior editor of the journal, and all the office bearers of and members of the organizing committee of this session and this seminar, and my dear participants. It is indeed a matter of great pleasure for me to be the part of this inaugural session. And first of all, let me congratulate uh, the the members of the society and the office bearers of the society and the Chanakya National Law School chapter of this society, who are running this very important society for a very important subject. And you have taken a pain to organize this one-day national seminar on a very contemporary issue. A friend, uh, since this program is being organized from the land of Bihar, and uh, nowadays I have become more interested in the Indian knowledge system and 5,000 years history of uh, our Bharat or our India, where I find the Nalanda and Takshashila, the universities, they have played a very, very important role. So there was a time when the Nalanda was one of the premier university in entire, not only in India, but entire Southeast Asia. And it was almost very difficult to get admission in universities like Nalanda. It was a specialized university. And much things have been written and many more things is to be written about the contribution of knowledge and the wisdom like our great universities like Nalanda and Takshashila. So I'm very happy that the organizers of this seminar belongs to that great land. And I'm also very happy that the Chanakya National Law School students have taken a lead role. And Chanakya has uh, a great contribution. Many persons may have some doubt or some suspicion about the role of Chanakya. There may be the merits and demerits of his personality, I do not know. But he has a great name in our discourse of knowledge. And that's why those who have named the Patna National Law School as Chanakya National Law School, they were not ignorant persons. And that's why I wish that in future, the Chanakya National Law School should initiate some academic program in the name of Chanakya, and wherein we should have the opportunity to discuss the contribution of Chanakya. A friend, this is a constitutional law seminar, and the society is for the very name of the society is Society for Constitutional Law Discussion. Friend, for perhaps more than 2 decades, I have been associated with this subject. And I'm reminded that when I was the LLB student at Allahabad University, I participated in a essay competition. And the theme of that competition was the constitutional position of president. And it was the God grace that I got the first prize in my law school during my LLB days. So I have developed some extra interest in the constitutional law, and that's why when I got the opportunity to do my LLM, I chose the constitutional law specialization at Banaras University. I'm very privileged to say that some of the great teacher of Professor R.K. Mishra and Professor C.M. Jariwala and many more, they were my teachers in the constitutional law subject. So whatever I have gained the insight, I would like to give the credit to my all the great teachers and my seniors and my contemporary colleagues and my students. A friend, uh, what is the constitution and what is constitutional law? Constitution is nothing but perhaps uh, it is supreme law of the land. The whole society is a playground, and whenever we play a game, there must be some rule. Without rule, we cannot play a game. Otherwise, that game will not be a disciplined game. There will be cheating, there will be might is right, and there will be so many things. And there will be no pleasure in playing the game, rather than there will be clashes. And that's why we need a rule in any game. And constitution is a rule of playing the game in our national polity. Whether it will be the democratic constitution, or it will be presidential form of government, or it will be the parliamentary form of government, whether there will be a independence of judiciary or judicial review, jurisdiction, how many fundamental rights will be given, how many economic and political rights or social rights will be given in the form of the DPSP, what will be the emergency provisions, whether 370 should stand for 70 years in the name of transitory provision, whether the transitory provision should be considered as the permanent provision, as many of us have argued that the 370 should be treated as a permanent provision. So why have you named it as a transitory provision if it is a permanent provision? So in the Supreme Court, Honorable Kapil Sibal and others, they have argued this line of thought that though the name is transitory, but it should be considered as permanent. So, okay, we are aware about the creative contribution or destruction on part of our eminent lawyers in the Supreme Court. So, friend, the Constitution. But let me say one thing. Having a constitution is one thing, and having a constitutional law is another thing. The Hitler had a constitution. Mussolini had a constitution. Stalin has a constitution. Ziaul Haq had a constitution. All the martial law rulers, they had a constitution. Saudi Arabia has a constitution. Saddam Hussein has a constitution. There are 200 countries in the entire world. And I think that hardly there may be one or two nations or countries, they may not have a constitution. So we have at least 198 countries having a constitution. But the question is, do they have constitutional law? So friend, constitutional law has been derived from the concept constitutionalism. So friend, what is the idea of constitutionalism? Constitutionalism, to my mind, is nothing but it is a set of certain progressive principles, certain well-conceived, well-developed, well-groomed, modern, rational, rule of law-based principles. For example, there should be a written constitution. Why constitution should be written? So that no ruler of the time should play with it. And that's why Constitution should be written black and white. Why Constitution should be supreme? Because this is the rule of the law, not rule of the men. You may have won the more than 400 Lok Sabha seat. I'm talking about the late Rajiv Gandhi ji. After the unfortunate assassination of her mother and our former Prime Minister, Srimati Gandhi. So under a very young and novice leadership of Rajiv Gandhi ji, Congress has won more than 400 seats. Even Nehru ji has never won more than 400 seats. So friend, what does it mean? If you have, now the people are talking about abki baar 400 ke par. So even if you have won the more than 400, just I'll take 2 seconds pause. I'm so sorry. There was some emergency in my home. Okay, am I audible? Ananya, am I
Yes, sir.
audible?
Yes,
Okay.
sir. Yes.
So let me resume my point. So even the Modi ji succeeds to win more than 400 seats. Now the people are talking about, no, we should not give 400 seats to Modi ji, otherwise he will become a dictator. Being a student of constitutional law, let me submit that. Even if Modi ji wins more than 500 seats, he cannot dare to become a dictator in a country like India, so long we have our constitution. If you ask the evidence, let me give you the evidence. The same Modi government, with the support of the Congress, has passed a constitutional amendment by 2/3 majority and has received the assent of the more than 50% states. I'm referring the NUJC constitutional amendment. National Judicial Appointment Commission Amendment and the Act. That was made by 2/3 majority, devising a consensus by both the two major parties, Congress and BJP. And perhaps this was the constitutional amendment which was perhaps nobody has opposed it. So there was almost consensus in the parliament. But what has happened? Our 5-judge constitutional bench has thrown away the constitutional amendment of NUJC in the ocean of this Bay of Bengal, has declared it unconstitutional. And friend, what has happened thereafter? And that judgment was not by the 13 judges bench or 9 judges bench, it was just by a 5 judges constitutional bench, and there was a dissent by Justice Chalmeshwar. So it was a 4-1 decision of the constitutional bench. So what I mean to say, practically, the 5 honorable judges of the Supreme Court can declare a constitutional amendment passed by the Modi government with the support of the Congress government as unconstitutional. So those who are arguing that the Modi ji is going to become a dictator if he receives the 400 seats, they are, I'm sorry, they do not know the constitutional law of India. So long our constitution is there, so long the constitutionalism will be there, so long the supremacy of the constitution will be there, so long the honorable Supreme Court and high courts will be there, so long the doctrine of judicial power of judicial review will be there, no person in India can ever dream to become the dictator. No. And this is, and let me say, this is not the era of Srimati Gandhi government. Now our judiciary has taken a lesson after the emergency period. Our judiciary has become more wise and more vibrant. Have you not seen the recent judgments in the electoral bond case? The right to information has been regarded as the constitutional right. An honorable Supreme Court has declared that scheme as unconstitutional and has ordered the central government repeatedly that you should furnish all the details in the public domain. And therefore, friend, what I'm trying to say is that my argument is that had there not been a clear-cut decision of the Honorable Supreme Court in the Ram Janambhoomi case, the no Ram temple could have ever been constructed in India. This is my thesis. So if the Ram temple has been constructed at Ayodhya, ultimately it was a natural consequences of a judicial decision given by the Honorable Supreme Court after a long legal battle. There was a district court, there was a high court judgment, then 15 years in the Supreme Court, then Supreme Court has given a judgment. And then after that judgment, the Ram temple has been built. Now the people are talking about the demand for the Gyanvapi temple at Kashi, where I live, and Ram Janam and Krishna Asthan at Mathura and many more. You cannot do anything unless the court permits you. So this is the beauty of our system. So if, and look friend, you have removed the 370 and you aspire to bring the Common Civil Code in India. But my submission is that unless the Supreme Court approves that, unless the Supreme Court permits you by using its wisdom, you may agree with the approach of the Supreme Court or you may not agree. That is another point. Because we are not slave of any person. So how can I be allowed myself to be a slave of even the judgment of the Supreme Court? I'm also a rational being. Judges of the Supreme Court, they are also a simple person. They have also done the LLB. Sometimes we have the more qualification than Supreme Court judges. Many Supreme Court judges are not LLM. They are not PhDs. So why I should allow myself to be the slave of the thinking of the or rationale of the Supreme Court? And Supreme Court itself has said in many times that we are supreme, but it doesn't mean that we are infallible. So Supreme Court is not infallible. Law is nothing, but it is a better argument. Law is nothing, but it is a rationality. So nobody can claim that I have the final supreme rationality. Law is nothing, but it is a dialogue. Let us have a dialogue. Let us convince each other. Let us find a consensus. And that is the beauty of a modern constitutional progressive democracy. Democracy does not mean 400 ke par. No, I'm sorry. Democracy does not mean 273 seats. No, I'm sorry. Democracy means a dialogue. Democracy means trying to find out the solution. Democracy means to win the hearts of the opposition also. Sabka saath, sabka vikas, that is the democracy. और सबका साथ सबका विकास डंडे के बल पे नहीं, मार्शल लगा के नहीं, और onslaught of the parliament majoritarianism नहीं. There is a difference between democracy and majoritarianism. You may have the 273 seats, but if you have the mindset of the majoritarianism, you are not a democratic person. And even if you have won more than 400 seats, 400 ke par, but if you have the mindset of dialogue and winning the hearts of our opposition, or having the spirit of sabka saath sabka vikas, then you are a democratic person. So democracy. There may be the many forms of the democracy. So in China also there is some so-called democracy within the Communist Party. But there is only one single Communist Party in entire China. Is it a democracy? In Pakistan, it is a democracy. In Saudi Arabia, is it a democracy? Putin has recently won the election with more than thumping majority. Now there are a very serious allegation against even Putin. How he has managed this 70% majority vote. Is it a democracy? So friend, what I'm trying to say is that there is a difference between having a constitutional and constitutional law. Constitutional law means supremacy of the constitution. Constitutional law means a written constitution. Constitutional law means separation of power, because power corrupts and absolute power corrupts absolutely. That's why let us divide the power of the state, check and balance. Constitutional law means a supreme guarantee in the form of fundamental rights under Part 3rd of the Constitution. Constitutional law does not mean only political right, but constitutional law also means to other justice, that is social justice and economic justice, which has been written in the preamble. And that is get reflected in the form of the DPSP. Constitutional law means supremacy of and independence of judiciary. Constitutional law means power of judicial review. And constitutional law means basic structure, Keshwanand Bharti case. And constitutional law means rule of law. And constitutional law means limited power to amend the constitution. Otherwise, you will have the 400 ke par and you will amend the constitution. There is some legitimate fear about this phrase, "Akki bar 400 ke par." There is some legitimate fear. People are fearing that this person may alter the constitution by 2/3 majority, because you do not have the right now. You do not have the majority even in the Rajya Sabha, simple majority, and that's why you are aspiring to get the is bar 400 ke par. So in the Lok Sabha, you will be more than 400, and gradually you will have the majority in the Rajya Sabha, so that you can amend the constitution as you wish. 2/3 majority, and half of the ratification of the state. So there is some legitimate fear. But let me assure you, though I'm not an advisor or advocate of Prime Minister Modi, I'm a student of constitutional law. So long our Supreme Court is there, so long we have the constitution, so long power of judicial review, which has been declared and held as basic structure of the Constitution of India in the Minerva Mill case. And so long we have a glorious tradition within the constitutional law. It is not the first time, but it was in many times Supreme Court has declared the law passed by or amendment of the amendment done by the parliament as unconstitutional. There are many times Supreme Court has done it. So Supreme Court is there. So even if you have got अब की बार 400 के पार, अरे भाई 400 पार नहीं 500 के पार कर लो, क्या फर्क पड़ता है? But you cannot, even if you have got the more 100, 500, इस बार 400 के पार नहीं 500 के पार कर लीजिए आप, लेकिन फिर भी आप क्या करेंगे? बेसिक स्ट्रक्चर को बदल देंगे. So long the 13 judges bench historic decision of Keshwanand Bharati is the part of the constitutional law. It doesn't matter even if you have the 400 par or 500 par. No, you cannot amend the basic structure of the constitution. So being a student of constitutional law, this is my submission. And the people of India are not fool. We have some maturity of having 70 years of the mature democracy. We are not the banana republic. We are not the banana republic. There are more than 1,600 law colleges and universities and lakhs of the law students and thousands of the professors. Civil society, vibrant civil society organizations, NGOs, independent thinkers, writers. Will we keep mum when our constitution will be destroyed? As someone will try to become a dictator? No. We have a vibrant democracy. There are many institutions. Okay, friend, let me come on some other points. Today's theme of the seminar is right to privacy and federalism. Let me say few minutes about the privacy and few minutes about the federalism. I'm very happy to learn that Piyush Raj has informed all of us that 42 research papers have been submitted for this seminar. I will look forward. I'm very happy that 42 large number, and I request the organizers that if possible record the events of all the sessions and put it at the YouTube or somewhere so that subsequently we will have the occasion to listen what our young friends have.
There are 52 papers. I'm sorry to interrupt. 52 papers.
Okay, now I'm more happy. 52 papers.
Yeah.
So 52 papers. This is very good. So friend, let me say something about the privacy. Friend, I'm sorry to say that our constitutional law does not apply to Google and Microsoft and ChatGPT. Their servers are not in India. We are at the Facebook, we are at the Twitter or X now. We are at the Instagram. We have the Gmail account, isn't it? And we are using this Microsoft Team, where there is a privacy. So if I want to have some private conversation with my girlfriend, and after the marriage with my wife, Where there is a privacy, either I will telephone her, or I will send a Insta message or WhatsApp message or Facebook private chat. Nothing is private. Google knows everything. Microsoft knows everything. And WhatsApp knows everything. So we are literally, we are right now, we are the slaves of certain multinational companies, and particularly Americans. We are all slaves of. This is a very serious issue. So nothing is even my father, my wife, my children, my students, my family members, my friends do not know even 10% of my daily life, but Google knows everything. How many minutes I have taken the morning walk today, Google knows this. How many times I have sent the good morning to someone, Google knows, and WhatsApp knows everything. You cannot hide. Even if you delete it, you think that I will delete it, but everything will be there in their server. You delete it. So friend, and do we have any research? Whenever we in our mobile, there are at least 50 applications. At least in every mobile, there are at least 50 applications. Every day we want to download one or another application. Is there any option? No, I accept. Where there is an option? In every application, there is only one option. I accept or I reject. Okay, if you reject, it will not be downloaded in you will be deprived. So do you have the capacity and option to reject the I do not have the account on the Facebook or Instagram or on the X or WhatsApp? Where will you go? Where there is option? There is no option but to accept yes. And that's why we are all slaves of all these companies. No right to privacy. No right to privacy. And lot of litigations have gone in European countries, in America, and but you know, the multinational corporations, they will hire the lawyers like Kapil Sibbal and Abhishek Manu Singhi and Salman Khurshid, and they will pay the 50 lakhs per day. And they know how to manage the Supreme Court. जितने भी नेशनल लॉ स्कूल के स्टूडेंट्स पढ़ के निकल रहे हैं और 5-5 लाख रुपए तनख्वाह ये पाएंगे लीगल फॉर्म्स में, they will not serve for us, for common people. They are all the good servants of the multinational corporations. They aspire to become the servants of the multinational corporation. Google में काम करना तो सपना है भाई. तो जो भी आपने 5 साल तक पढ़ रखा है, जितना भी लॉ, वो सब तो आप गूगल के लिए यूज करेंगे, उसको डिफेंड करेंगे आप जाकर के लीगल फॉर्म्स में.
Sir, I'm so sorry to interrupt you. Sir, I'm so sorry to interrupt you. We are really running out of times, and paper presentations will also start at 12. So if you could please.
Okay, I'll take only 2 minutes time.
Sure, sir. Sure. Thank you so much.
I'm talking about the practical aspects. Because I have not seen a single case where the bright students of the national law schools have fought for any genuine public cause against the multinational corporations and they have succeeded. I will be very happy to learn. and they don't want, they don't want to be an independent lawyer. Everybody wants to be a humble servant of the all the multinational corporations. Okay, friend. So right to privacy, great challenge. But I'm very happy that our Honorable Supreme Court has declared the right to privacy as a fundamental right in Aadhaar case. But friend, one of my professor at Banaras Hindu University used to say one dialogue, and that is, you deserve a right as you can fight for them. Constitution cannot give you the right. A legislation cannot give you a right. It can facilitate. So if you want to get a right, you have to fight for that. The question is, do we have capacity to fight for that? And that's why capacity building. The more power, more energy, more enthuse you have, more commitment you have for fighting your rights, more rights you will enjoy. Nobody is going, even the Supreme Court will not going to give you the right. Supreme Court does not give any right suo moto unless you file at least a PIL. नहीं, आप बता दीजिए सुप्रीम कोर्ट ने कौन सा ऐसा जजमेंट दे दिया आज तक 70 सालों में अपने से बिना मांगे दे दिया आपको, suo moto दे दिया? No, you have to fight a case. You have to file a PIL at least. You have to fight a legal battle in the Supreme Court. And that's why, friend, you deserve only those rights for which you have capacity, you have zeal to fight for that. And friend, lastly, I'll take only 1 or 2 minutes for federalism. Many of my friends will submit a paper on 370. But when you support the retention of 370, do you understand the geopolitics? Do you understand the geoeconomics? The Pak occupied Kashmir has already been gifted by the Pakistan to China. In 1964, the China has grabbed your thousands of the miles of land. It has colonized the whole Tibet. It is claiming your Arunachal Pradesh. Okay, strengthen 370 and conduct a plebiscite in Kashmir. You conduct it, and the Kashmir will go in the hands of the Pakistan, and the Pakistan will hand over to your entire Jammu and Kashmir to China, and the Chinese army will be very near to your Punjab and Himachal Pradesh. That will be the natural consequences of conducting a plebiscite in Jammu Kashmir and to strengthen 370. So friend, when we talk about, let me say one thing. They read the law without economics and geopolitics, and therefore I will request those who are listening me today, I will request everybody. I will request everybody that please do conduct some research on laws in the light of the geoeconomics and geopolitics. So if we are going to advocate the retention of and criticize the abolition of 370, you must take into account your security problem, security threat. The Himalayas has been our great protector in last 5,000 years. Okay, give the Kashmir to Pakistan. Your half of the strength of your army will be go down. And therefore, friend, okay, 378, 370 was a promise and all these things, so many hyperbole and so many things. But have you forgotten that it was a transitory provision? So how a transitory provision can become a permanent? So if the government of India has decided to abolish a transitory provision, why there is so much hue and cry? Okay, let us debate about the manner of abolishing that. Let us debate the constitutional aspirations of the people of the Jammu and Kashmir. But don't forget this fact that from last more than 25 years, the terrorism in Jammu Kashmir has been funded not by Pakistan, but it was by China. Do you know this? 90% people understand that it is the Pakistan who is funding terrorists. No, I'm sorry. अरे पाकिस्तान के पास खाने के लिए नहीं है भैया पैसा, आज की डेट में रोटी के लिए पैसा नहीं है, वो क्या फंड करेगा? पाकिस्तान का तो एटॉमिक बम उसका अपना है ही नहीं, चाइना ने दिया है। आज अगर चाइना पाकिस्तान को पैसा ना दे तो पाकिस्तान भूखा मर जाए यार। IMF अगर पैसा ना दे तो वो भूखा मर जाएगा चाइना। वो पाकिस्तान, ये हालत है उसकी, इकोनॉमिक बैंकरप्सी पर है वो। उसको अपना इंटरेस्ट भी देने के लिए लोन लेना पड़ता है, इंटरेस्ट का इंटरेस्ट देने के लिए लोन लेना पड़ रहा है। दैट इज द इकोनॉमिक बैंकरप्सी ऑफ द पाकिस्तान। सो पाकिस्तान कैन नॉट फाइट विथ इंडिया, it is China which is fighting from with India through the Pakistan. So friend, I request my young friends, then don't become emotional. If the rights of the few lakhs people are very important in Kashmir, then the rights of the 140 crores and security of 140 crores of the we the people of India are also very important. 700 सालों तक तो हम लोग गुलाम रहे। We don't want to become slave of China or America or anybody else. And that's why our security is important. Our Arunachal is important. Our Jammu Kashmir is important. Our Uttarakhand is important. Okay, friend. I'll point out one more. There are many more things. So far, the federalism is concerned. What is federalism? Federalism is nothing but respecting the autonomy of the people, respecting the culture, language, regional aspirations of the people. And friend, India, for what India is famous? What is the civilizational contribution of India? I'll take only 1 minute. What is the civilizational contribution of India at the global level? It is nothing but unity in diversity. Tell me one country in the entire globe where there is such huge diversity is there. So many religions, so many hundreds and hundreds of languages, culture, geographical diversity, different things. But there has been some common thread, some common aspiration, some common feeling, some common bondage. And that is the civilizational. The India has given a perfect example to the entire globe that how 140 crores people can live together with peace, with shared common interest. So India has a glorious history of celebrating the very concept of federalism. And I don't agree with the definition of Professor Casey Ware, who has written this so-called perfect definition of federalism in the light of the American Constitution. What a foolish argument is this? That if Indian Constitution does not in consonance with the so-called ideal federalism of America, India should not be called as federal. What a foolish argument. America is a country of migrants, friend. Is it a country? So it is just a common union program. 50 states come together. एक वोट से जर्मन लैंग्वेज रह गई अमेरिका में उनकी ऑफिशियल लैंग्वेज बनने से, पता है ना सबको। आज अगर अमेरिका में इंग्लिश लैंग्वेज वहां की ऑफिशियल लैंग्वेज है, केवल वो एक वोट से, है ना। तो आप वहां स्टेट्स में जाइए, देखिए वहां पे फ्रेंच का डोमिनेशन है, वहां जर्मन का है, पुर्तगीज का है, स्पेनिश का है ना। अमेरिका इज नॉट अ वन नेशन, इट इज द कंट्री ऑफ माइग्रेंट्स। और उनका कॉन्स्टिट्यूशन उनकी उस हिस्ट्री को रिफ्लेक्ट करता है। दैट्स व्हाई दे हैव डिवाइज्ड द फेडरलिज्म, है ना। और उनकी फर्स्ट 3 आर्टिकल्स उस सेपरेशन ऑफ पावर को रिफ्लेक्ट करती है। बट आवर सिचुएशन इज डिफरेंट। We had the under subjugation of 700 years, and that's why we need a strong New Delhi. We need a strong New Delhi. That's why it is not necessary that our federalism should accord to American. And now the Professor Casey Ware will say that Indian Constitution is quasi-federal. What does it mean? Do you have any perfect definition of federalism? Do you have? And whether the perfect definition of federalism should be that definition which the American have. So this is nothing but it is a colonial subjugation. अरे भाई हम लोग आजाद हो गए ना 47 में, तो 2024 में क्यों अमेरिका की गुलामी कर रहे हैं? कि अगर इंडियन कॉन्स्टिट्यूशन अमेरिका के कॉन्स्टिट्यूशन के हिसाब से नहीं है तो हम फेडरल नहीं है। अरे आप ये क्यों नहीं कहते कि अमेरिका का कॉन्स्टिट्यूशन इंडिया के हिसाब से नहीं है, इसलिए वो फेडरल नहीं है? And that's why, friend, I'll take just 30 seconds. Yesterday I had a discussion where the 12 professors of law were there, and we were talking about the possible reform in syllabus. And one of my friend from New Delhi, he has pointed out this fact that in India there was a constituent assembly debate and there was a concept functional federalism. There is no permanent or straitjacket concept of federalism. We have the functional federalism. So federalism is there. Where there is an interference of New Delhi in the Tamil Nadu or in Kerala and all these things, functional federalism is there. So when there will be some crisis, the New Delhi should intervene. And look, friend, distribution of power is there, financial distribution is there, finance commission is there, administrative distribution is there, and all Supreme Court is there. So if the New Delhi encroaches upon, then Supreme Court is there. Now, have you heard in last 5 years or in last 10 years, there is any arbitrary use of 356? Have you heard? Perhaps only one or twice. No, there is no trend of any use of or misuse of 356. Why? Because the Bomai case, Supreme Court has decided that you cannot decide the constitutional failure of constitutional machinery on the political basis. So, friend, I'm very sorry, Piyush, I'm very sorry that I have taken some more time, but the time is not permitting. I have perhaps the 25 years of learning the law, and every day I learn, every day I earn my bread, and even today at least 3 to 4 hours I listen lectures of others. So I'm open to I'm always open to listen any voice which does not agree with me. So I'm very thankful to the organizers who have given me this opportunity to share my views. Thank you very much.
Thank you so much, sir. Thank you so much. It's an absolute honor to have you today. and that's okay. Actually, the technical session needs to start, so that's why. Otherwise, your speech was very insightful, very uh, elaboratory, very thoughtful. So thank you so much, sir. Thank you so much once again for coming here and speaking the insightful voice. Thank you so much.
Thank you, sir, for your insightful words on evolutions and challenges in constitutional law. Experts like you to guide us in the current political and legal situation is the need of the hour now. I'm sure each one present here must have gained valuable insights about constitution, privacy, and etc. Now we were going to have our welcome our chief guest, but due to some engagements, he left this meeting. So now I would like to welcome Mr. Ayush Kumar, the managing head of the core team, the Society for the Society for Constitutional Law Discussions, for his vote of thanks. Over to you, sir.
Thank you, Ananya. Am I audible?
Yes, sir.
Thank you. Good morning, everyone. Good morning, guests, esteemed scholars, and dedicated volunteers, and all the participants. It is my privilege to extend a vote of thanks on this momentous occasion. My name is Ayush Kumar, and I'm the managing head of the core team members at the Society for Constitutional Law Discussion. Firstly, I would like to express my my gratitude to Professor Dr. Ajay Kumar, the chief guest. However, due to his constraints, he couldn't speak. He had to leave the meeting. I must acknowledge the contribution of Professor Dr. Shailendra Gupta sir, our guest of honor, whose expertise in constitutional law provided us with the challenges, and we discussed various cases of contemporary relevance. A special thank you to Mr. Piyush Raj, the senior editor at the Society for Constitutional Law Discussion. I cannot proceed without thanking Ms. Ananya Astri, who provided an excellent introduction to the seminar themes and objectives. I thank to all the paper presenters and participants. Your research and perspectives are what truly transform this seminar into a vibrant forum for knowledge exchange. Thank you for your contributions and for fostering a scholarly spirit. I extend a heartfelt thank to the core team member of the Society for Constitutional Law Discussion, along with all the team members and volunteers who work tirelessly behind the scenes to ensure that the event goes smooth. Your efforts have been pivotal in the success of today's event. Lastly, I would like to thank all the attendees for your engaging participation. On behalf of the Society for Constitutional Law Discussion, I express my sincere appreciation to everyone. Thank you.
Thank you. All the best.
Thank you so much, sir.
Thank you, Ayush, sir, for your vote of thanks.